Hello, everybody. Welcome to the 20th episode of Let's Talk. I'm very happy to welcome you today. I have a very special friend and also a real estate attorney and a very well known leader in the Spanish community. Welcome, Eneida.
Gracias. Thank you.
Yeah, so Eneida, would you like to say or tell a little bit about yourself before we dive into the topics?
Of course, of course. Well, first of all, thank you so much for hosting this, Elena. I'm delighted to be here to discuss real estate trust and how we may best protect our assets through estate planning. And like you mentioned, I am an attorney in Boston. Right now, I have my office in Wellesley. I was in Boston for 15 years, but I serve the greater Boston community. And I focus on real estate and estate planning for the most part in my practice. And so I love to share knowledge and share wisdom with my clients because it's so important that we understand the tools that are available out there to protect our assets and our loved ones. So thank you.
Awesome. I can't wait for today's topics. I do serve clients and also investors. So this is a topic, a relevant topic to address. So I'm happy that you decided to accept the invitation to be part of this program. So for the audience out there, I want you to encourage you to leave us like your comment, question, thoughts that you have that you would like to ask Eneida today. So we will be answering them as it comes. So let's just go into the topic, Eneida.
Yes, of course. So the topic that we chose today is called Real Estate Trusts, Estate Planning Strategies and Alternatives for like you said, investors or owners of real estate, because there are so many tools available for owners of real estate to protect their assets and to stay away from costly court proceedings and the like. And so you will see the slides on your screen right now. And essentially, the first thing that I'm going to discuss is why having a real estate trust is a good alternative. So can we have the next slide, please?
And before you talk about that, like define the property. Does it have to be an investment property, or can the trust be on your property that you live in?
That's an excellent question. You can have any real estate property in trust, and so the whole purpose of having this, and I'll go into more detail, is to make sure that you have a more flexibility and privacy, and and the ability to benefit your loved ones or whoever you want to benefit, right? Because very big picture, what happens when you own a property in your name is that if you own it with your spouse, then by default, if anything happens to you when you pass away, automatically it goes to your spouse.
Mm-hmm.
There are other ways of taking title. If you own a property with other individuals and there's a right of survivorship, then the property, essentially your shares, transferred to that other person. And but if you hold title differently where your heirs inherit, then your part goes down to your heirs, and then the other part remains with the other owner. So there are different ways, right? But what happens is that if we don't have an estate plan and we don't plan for succession of our assets and our anything that is part of our estate, um, what can happen is that you can end up in court because even if people have a will, it's a requirement to go to court and for the court to authorize the distribution of your assets. When individuals place their properties in a trust, you bypass that, right? Like you don't have
Mm-hmm.
to go to court, and we'll go more into detail on how that can happen.
Mm-hmm.
Essentially, it allows for more privacy because you don't have to disclose who your beneficiaries are, right? So
Right.
It gives more flexibility to the trustee because even if the grantor, which is the person that, that originally had title, passes away, even if they're the trustee, then you always have a successor trustee, which is somebody who takes over when you are no longer available to serve as trustee. So there's a continuity of ownership instead
Mm.
of interrupting anything that can be done with the property during the time that that there's a court case pending. And not to mention that being in probate court, right, that's what it's called when you have to deal with people's estates, is very time consuming and very expensive. So doing this is an investment for the future of your loved ones, for sure.
Mhm. So when you say continuity of ownership, like say someone passed away, and then there's this other spouse gets the property based on the trust or whatever designation.
Mhm.
Does that mean, like, I mean, you may or may not know this question since it may be an accounting question, but does that mean like we avoid that kind of tax implication?
That's an excellent question. So tax, I'm not a tax attorney, first of all.
Yeah. Mhm.
I always work with, with tax attorneys and with financial planners with my clients, but generally speaking, Massachusetts has a $1 million exemption, right, for spouses.
Mhm.
And the federal level is much higher. It's like over $12 million, and that's going to change, right, because that depends on the changes that happen at the federal government. Massachusetts has one of the lowest thresholds as it relates to to taxation. But remember, a trust is a legal entity on its own, so
Mhm.
trust will pay taxes, right? So the question of the spouse and the taxation is a little bit separate than that the question of taxation of a trust, because regardless, the trust will have to it has its own life, right, and will have to pay its own taxes.
Got
And
it.
other implications. I mean, there's we could be here talking for hours, right?
I know.
There are implications about like what a trust can own, especially after somebody dies. For example, if it's you can structure a trust so that it owns LLC, so that it owns obviously business and real estate and everything, right? But there are certain thresholds to allowing the trust to own businesses, particularly after a person, the grantor, has passed away. But with real estate, that's not the case, right? With real
Got
estate,
it. Yeah.
there's
Mhm.
more continuity. So, again, it can be a little complicated, and there's a
Yeah,
lot that goes into this.
of
But
course.
speaking, taxation, yes, there is taxation for the spouse if it goes outright to the spouse, but the trust itself would also, be a legal entity on its own to focus on the.
Got it. Okay. And what other benefits, or do you think, like, why a trust like makes sense?
I mean, I think, privacy is huge, right? Because you can have beneficiaries and you don't have to necessarily tell the world that, that these are the people who are the beneficiaries of your trust.
Mhm.
So what happens, and again, we'll go into more detail as we continue the conversation. But if you want, why don't we go to the next slide? Because I do go into this a little bit in the next slide. Um,
Sure.
so so essentially, what happens is that if you have a trust, first of all, like I said, you don't have to worry about the probate process because it's time consuming and expensive. Um, you can have because when you transfer ownership, so let's say right now you have your property, right, your family home, and you
Mhm.
that I wanna transfer this into my trust. I want to create a trust and I want to transfer it. So what we do is we draft up a trust document based on your wishes. We have a very specific conversation about what your goals are, what you visualize, what you want to leave, who you want your beneficiaries to be, etc. And so the trust will have all the details, all the private information about what you want your kids or your spouse or a charity or whatever you want, right? Like it depends on how you want to structure it. um, and that document is private. Nobody in the world except you and your attorney and whoever else you want to share this with will know what's in that document. However, you do need to file a certificate of trustee, right? Because essentially what you are doing is transferring ownership from Elena Lau to Elena Lau as trustee of the Elena Lau Trust, or however you want
Mhm.
to call your
Right.
trust, right? And so you are the fiduciary. Your name is public. You know, people know, like the world knows that you're the trustee of this trust, but that's it. Nobody else is going to know who your beneficiaries are. So I like that because it allows for, you know, for flexibility and naming your you know your heirs and your beneficiaries without the world knowing. Because by the way, you know, when you file a will in probate court, that does become a public record, right? So the world will know who your beneficiaries are, and the world will know who is fighting, who's not fighting, who's saying, you know, that they agree with you, or anybody who's challenging your will, etc. So there is a privacy shield that is very convenient with trusts.
Good to know.
Yes.
So I see that there, my understanding is that there are different type of trusts.
Yes.
Can you help us differentiate each of them or what the functions are?
Absolutely, absolutely. So if we go to the next slide, I highlighted two primary trusts that you know that I work with clients, and one is called the Nominee Trust, and the other one's called the Revocable Trust. Okay, nominee trusts were more common before 2003 because in 2003 the law changed. The you know estate
Mm,
laws changed. And so before, you know how I just mentioned that you only have to record the certificate of trust,
mhm,
or individuals who created trust had to record the entire trust. And so what lawyers would do to kind of bypass the public element was to create a nominee trust that where the trust was the beneficiary, and that way the trust was not public. But you know, I'm explaining all this to give you the explanation of why there's a nominee trust. And it's still, I mean, people still use it, right? But then you still at some point wanna also create a trust if you wanted to focus on other assets that you have. Uh,
mhm,
so so a very important distinction is that in the nominee trust, the beneficiaries control. Okay, in a revocable trust, it's the trustee that controls. And so
mhm,
depending on what interest you have in terms of protecting your assets or passing on benefits to your or money to your beneficiaries. So, for example, I have clients who own property under a nominee trust. They hold the property under a nominee trust. The trust, essentially, the trustee is you know is responsible for obtaining authorization from the beneficiaries for any decision that's made, and also the beneficiaries can receive money right throughout. So if it's
mhm.
investment property, it makes sense to have the property under a nominee trust because then you can distribute monies to your beneficiaries, and you can take advantage of the $15,000 per year gift exemption for
Mhm.
beneficiaries, and then the difference obviously would be taxable. So let's say you own a building that is an investment, and it generates $1 million in a revenue per year. Just to give you know like
Yeah.
very generic numbers, right? And you have two beneficiaries, and so each beneficiary would get $500,000. Out of those
Mhm.
$1,000, $15,000 is tax free because it could be considered a gift, and then the other is taxable as income.
Got it. Okay. So for these two type of trusts, like does it only apply for one property? Say that there is this person that owns several real estate property. Can one trust hold all the real estate property, or do you advise that it's held in different trusts for protection purposes?
Yeah, I mean, you could. It depends on what you want to do. Again, I think it's really important to have a conversation about what your goals are, depending on what you want. I mean, you can have multiple properties under the same trust. You know, I have clients that, especially investors, they like to sometimes have different trusts. But if what we're thinking of is legacy and estate
Mhm.
planning and benefiting your family, then you definitely want to have that one trust that, that is, is the conduit for everything. Even if you have other instruments that transfer ownership to that one trust that is your legacy trust, if you will.
Got it. Okay.
Okay.
What other information do you have for these two type of trust?
Yeah, of course. So then the other very common trust that I work with my clients is called a revocable trust, because a revocable trust essentially allows for the trustee to control. And that I see a lot, that like when you have your family home that you want to put it in the trust just to protect your family, but you still want to hold control over the asset, right? You don't want your beneficiaries to have to decide what you want to do with,
Mhm.
particularly like, if you have minor children, like children are not are not legally capable of making those types of decisions. So it's good for then the trustee to serve as a fiduciary, and always, of course, acting in the best interest of the beneficiaries, because there's this duty to ensure that you do what's right by them, right? And
Of course.
so that is actually typically more common for a lot of
Mhm.
clients. So when I see the nominee trust is more when there's already like some adult beneficiaries that you want them to benefit from that during the life of the nominee trust. That doesn't mean you can't do the same with a regular trust. Again,
Mhm.
the law changed in 2003. It's more common to have the revocable trust. And I use the word revocable very intentionally because people think that trust sometimes cannot be changed, cannot be modified, and it's really important to understand that if you have a revocable trust, you can modify it if need be, right? You can restate the terms of your trust if you decide that you want to modify anything. There's also the trusts that are not revocable, that are permanent trusts, that once you create them, it's you can't change them. And
Is that the nominee trust?
no, no, no.
No, 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 no. Okay.
Yeah, nominee are also, relatively, flexible, right? Because you can do various things throughout the life of that trust. In fact, like even, modify the beneficiaries and all of that.
Mm.
So with the revocable trust, you can restate the terms of the trust, but once the grantor passes away, it becomes irrevocable.
Mm.
Okay. So,
Got it. Okay.
during the lifetime, and there's another term that's called inter vivos, right? It's a Latin term that means, during the lifetime of the grantor, who can also be the trustee, you can control the assets, right? That, anything that's within that trust, anything that would fall under probate. But you're doing it so that you can bypass probate.
Mhm.
And so once the grantor passes away, it becomes irrevocable, and then there's different ways of managing that, right? So depending on again what your priorities are. I have clients who when they've asked that when they pass away, in order to protect their spouse, then you divide the trust into two trusts, a family trust and a marital trust, to protect that $1 million exemption that the spouse gets, depending on whether they have a spouse. If they only have children, then there's different structures. So again, it's very unique to the needs of each client.
Mhm. So that's good. That is flexible and it can adjust according to the individual needs and wants.
Right. And so
Mhm.
I always tell my clients that, they want to revisit their trust every few years, because life changes, right? I mean, you could be married today, tomorrow you're not married. And so obviously, assets, then you don't know what a court could order if you have to transfer assets because there's a division of the marital estate. And so that would change. And then, you have, or, if you decide, I want to add this to my trust, I want to modify. So then
Mhm.
that is what is called a restatement of a trust, right? And usually want to do it with the same person, the same attorney who you initially worked with, so that there's continuity of the knowledge of what the intention was of the
Mhm.
grantor initially.
I see. So what are the other practical considerations that we have to think about when working with a trust?
Yeah, yeah. So again, that's excellent. I think I have another slide where where I think slide number 10. There we go. Other trust considerations. Exactly. So we kind of touched upon this already, but very importantly, it's a person that serves as a trustee has to be somebody who is, who is of your utmost trust, right? Because the word says it itself. It's somebody who you must trust, and that is going to serve as a fiduciary to the best interest of your beneficiaries. Um, and I also mentioned the tax exemption, the 15,000
Mhm.
exclusions. Right now in 2021, it's $15,000 per beneficiary. So you can structure in such a way that your beneficiaries receive the gifts, the annual gifts, tax free. Um, and so I mentioned the other point already about the continuity and not
Mhm.
interrupting because of death. And and last but not least, a trustee, regardless of what happens to the grantor, can do can make decisions on behalf of the property or properties as needed, right? And something that I believe I mentioned in one of the other slides, it's that it's really important to also understand that there are people that really don't understand how trusts work, and so you could face a situation where if you want to, if the trustee wants to refinance the property, they might have some issues, or if they're in a bank or something. So it's important to, to be well versed once have a trust, you create a trust, that you yourself as the, as the grantor or trustee, understand how trust works, so you can also educate. And that's, that's a continuous
Yeah.
conversation with your attorney. And also something I've seen, obviously working with both estate planning and real estate, is that, financing for properties under trust can sometimes be tricky because the interest rates might not be as, particularly, at times like now where interest rates are so low, um,
Mhm.
you might not have the same benefit. So oftentimes what happens is that people will remove the property while they're going through that process. They will remove the property out of the trust, and and then bring it back into the.
Okay. Okay. That was my next question to you. Like, do people do take it on and put it back? And
Yeah.
like on the audience, we have Martin who is asking, like, what are the legal costs and fees of setting up a trust? And
Mhm.
then that's the cost differ depending on the type of trust that's being set up.
Well, that, that depends on the needs of the individual. But I mean, usually I always tell people, to budget around $5,000 to begin setting up some, some sort of protection with a trust. But it really depends on the individual, if it's more than one person, if it's one person. So it kind of varies, but I would say like a, like a typical number is around the $5,000 range, to, to set up an estate plan, right? With a trust and with all the protections that are guaranteed with this type
Yeah.
of.
So when you talk about like the estate plan, does that also include like the will and all the different tools or instruments?
Absolutely, yes. So an estate plan is a battery of documents. I create a file, a binder for my clients. Obviously, we work hand in hand to discuss the needs, the preferences, the, the expectations, the goals, and then we create a binder with, with a will, a power of attorney, healthcare proxy, living will, digital directives, all sorts of documents that will be good both during the lifetime of the, and of course the trust, right? If they want to trust.
Mhm.
But these documents are helpful during the lifetime of the grantor and after death, right? Because for instance, let's say that you don't have a trust, and that you don't have a trustee, that you only created a will and a healthcare proxy, right? And
Mhm.
have a power of attorney, right? Because people sometimes oftentimes what happens is that people, like when you go into any hospital, they'll have you sign a healthcare proxy. So
Right.
it's not atypical for people to have healthcare proxies when they go to a hospital. And then maybe they say, well, I only need a will, I don't need anything else. And they're not thinking of like other potential consequences, right? So essentially, if they only have a will, let's say, God forbid, something happened to you tomorrow and you only had a will and a healthcare proxy, for anybody to make any decision at all for you, financial or anything that has to do with assets, with money, they would have to go to court and request permission from the court to obtain what is called a conservatorship, right? Because then they would essentially be telling the court, Elena is no longer capable of making transactions, financial decisions for herself. Somebody needs to step in for her to serve as her fiduciary, right, as her conservator. And that too is super complicated, super expensive. I mean, it's really burdensome. So you bypass that by creating a power of attorney, right?
Mhm.
Attorney will only be triggered if two physicians, I mean, the way that I draft them, right? If two physicians have already certified that you're unable to make decisions on your own. And so that person would serve as your attorney, in fact, right? As the person that would be able to continue making payments on your home, on your investment properties, continue investing on your behalf, etc., so that so that in spite of your, temporary or permanent incapacity, that person can continue serving on your behalf. And so a trustee is an additional layer of protection, right? Because then if you put all your assets into a trust, then that trustee, regardless of your incapacity or whatnot, can still support, can still serve to make sure that you're protected, right?
Of course. Yeah.
Another really important consideration is the fact that if you create a trust, you need to fund it, right?
Mhm.
So what funding means is that you need to transfer ownership of whatever assets are named in the trust to the trust. So like bank accounts, real estate, anything that is an asset needs to be then titled to the trust. So you as trustee of the trust X, Y, and Z, right?
Oh,
And
wow.
because if you don't do that, then the trust hasn't been funded, and it's almost like it didn't exist. So that's why I always like to create, the will, the power of attorney, and everything, even if I create a trust, because if it just so happens that you never got around to transfer
Mhm.
the assets to the trust, then at least you have the protections of the power of attorney and the other documents that are part of your estate plan.
Oh, that's a good thing to know. So
Yeah.
we had two more questions from the audience, and then we are just 1 minute away from the end time. So from Martin, he would like to know: are there trust laws that are different from each state? And what states are you licensed to set up a trust for a client?
Yes, of course. Absolutely. Yes. The answer is yes. Every state has its own code. So definitely. And I work in Massachusetts. I'm licensed in Massachusetts, so I can help Massachusetts residents with their setting up of a state plan. Another consideration that is really important that I don't want to go without mentioning. I think
Mhm.
the slide that's titled "Practical Considerations," probably slide 11, is that you want to make sure that transferring the ownership from yourself as an individual to yourself as trustee of your trust, or another trustee, and for the trust that you decide to create, that the lender doesn't, that doesn't impact the terms of the mortgage of your
Mhm.
property or properties. You also want to make sure that that the insurance policies are titled to the trust. Again, everything needs
Mhm.
anything and everything related to the property has to name the trust, because if anything happens, the property is titled to the trust, but then the insurance policy is in your name, then
Mhm.
that would, again, insurance companies, not that I have anything against insurance companies, but they could use that as a reason not to pay off whatever
Oh,
benefit.
I see. So basically, anything has to match to this trust, which is a new entity, basically.
Exactly, it's a new legal.
Mhm.
And also,
Got it. Okay, one more question from William. Is it recommendable to also include a homestead declaration when preparing a trust?
absolutely, you can do that. Yeah, if it's your homestead, absolutely, you can do that. Yes, that's a great question.
Okay, any final thoughts before we go?
I also the following slide that is titled More Practical Considerations. Also, I wanted to make sure to, let the public know that just because you have your property in a trust doesn't mean that, you're shielded from creditors or, taxes or estate taxes and all that. So that's why it's important to talk to an estate attorney and your tax consultants and everybody that works with you to make sure that you're shielding your property and protecting your property and protecting your loved ones, but also making sure that it's done in the most tax effective way. And there are other strategies, and I mentioned here like irrevocable Medicaid trusts that are also a good tool for protecting assets, particularly because elder care is so expensive. So those are some strategies, and we won't go into that because that's a whole webinar.
Maybe we need another episode to go deeper.
Yeah.
But one more question came in, if you don't mind answering it.
Yes.
Is from Suji. If a grantor has property in different states, do different trusts have to be created in each state, or can they be in one overarching trust?
They can be in one overarching trust. Yes.
Awesome. All right. Well, thank you so much. This has been a lot of information, especially relevant. So I really thank you so much, Eneida, and all our audience for tuning in today. Don't forget to subscribe to our channel on YouTube, Facebook, Instagram, as well, Union Real Estate LLC. And if you have any questions, feel free to contact us. Have a good day.
Thank you. Bye-bye.